Hello friends! Today we are going to talk about the Supreme Court of Canada, which means doing a lot of compare and contrast with the Supreme Court of the United States. Because much like Canada itself, it is impossible to conceptualize the Canadian Supreme Court without first starting with some sort of American reference point. The analogy is actually quite important in this case because Canada and the United States are quite unusual countries, globally speaking, in terms of just how much power they give to their Supreme Courts in the first place. Both the American and Canadian Supreme Courts have the authority to overturn laws they consider unconstitutional, as well as expand or restrict the meaning of laws or constitutional clauses. This is sometimes called a political system of judicial supremacy, in the sense it gives the Canadian and American judiciaries final say over public policy, which is not a thing that tends to happen as much in other countries. Accordingly, in both Canada and America, it is Supreme Court rulings that have often settled some of the country's most contentious political debates. Same-sex marriage, of course, came to the United States as a result of a Supreme Court ruling. And historically, the court has played a major role in imposing stuff like racial desegregation, as well as defining concepts like the separation of church and state, or freedom of speech. In Canada, meanwhile, our Supreme Court has issued definitive rulings on things like the death penalty, prostitution, doctor-assisted suicide, as well as esoteric Canadian issues like the unique rights of French speakers. And of course, one very big thing both countries have in common is that their laws governing abortion were largely set by their respective Supreme Courts as well. Which is why, incidentally, both Canada and the United States have some of the most liberal abortion laws in the world. But what is also important to realize is that in both Canada and America, this whole setup is relatively recent. This idea that the Supreme Court should play this domineering role in the government of either country is not something that anyone really planned from the beginning, but is rather something that just kind of gradually evolved over time. A few weeks ago, I made an award-winning video about the modern history of the Supreme Court of the United States, so we won't rehash that here. But basically, it only really became super powerful after the end of World War II, and the same was true in Canada. Canada, of course, remained a colony of Great Britain well into the 20th century, and one byproduct of this was that for a long time, Britain remained not only the highest political authority over Canada, but the highest judicial authority too. Canadians could appeal decisions of Canadian courts to the Supreme Court of the British Empire, or what was known in those days as the Judicial Committee of the Privy Council. But you know, as Canada came to gain more and more control over its own affairs, this setup became more controversial and was eventually scrapped. Britain's Judicial Committee made its last ruling for Canada in 1960. Now, throughout all of this time, there was technically a Canadian Supreme Court as well. It was established in 1875 by long-forgotten Prime Minister Alexander Mackenzie. But because important cases could just be appealed to Britain, the so-called Supreme Court of Canada existed for most of its life as just a mid-level appeals court. According to this excellent book on the Canadian Supreme Court entitled Mighty Judgment, author Philip Slayton says that for many decades, the Supreme Court of Canada was a sleepy institution working on the fringes of Canadian life and a peripheral presence in government. All that changed with Prime Minister Pierre Elliott Trudeau, who really shook up the Canadian judicial system as he shook up so many things. In 1975, he reformed the Canadian Supreme Court to make it more like the US Supreme Court, in the sense that instead of just being a general appeals court, the court would have the power to only hear cases that its judges said involved some issue of public importance or the importance of any issue of law. Or in other words, really important and interesting cases involving fundamental questions about the law or constitution. Everything else would just be settled by some lower appeals court. And of course, by this time, Britain was out of the picture, which meant that the Supreme Court of Canada was now officially the ultimate authority over Canadian law and justice. Then, in 1982, Prime Minister Trudeau and the provincial governments amended the Canadian Constitution to add something known as the Charter of Rights and Freedoms, which for the first time clearly articulated the fundamental human rights of all Canadians. It also added two other important provisions, a provision saying that laws that violated constitutional rights were of no force or effect, and a provision saying that Canadians could seek remedy from the courts whenever they felt their rights had been violated. These reforms all brought the Canadian legal system more in line with American norms, which is something that a lot of Canadians had been wanting for quite some time. Canadian citizens gained greater protection from their government's ability to pass oppressive laws, but it also gave the Canadian judicial branch much greater power over Canada's elected governments. In short, judicial supremacy. Almost immediately after these reforms took effect, the Canadian Supreme Court began tossing out laws deemed unconstitutional for violating the provisions of the Charter of Rights, and the rest is history. Okay, now let us talk a bit more about the Canadian Supreme Court itself. The Supreme Court of Canada consists of 9 judges. On ceremonial occasions, they wear these thick robes made of red and white Canadian fur, which people are always delighted by because they make them look like Santa Claus. The law says that 3 of the 9 judges have to be from Quebec, because Quebec law is apparently so different, no non-Quebecer could possibly understand it. And because this country is so badly divided regionally, there is also a convention that at least 3 of the judges should be from Ontario, and the other 3 should be from the other places. You know, to be fair. The judges serve until they turn 75, at which point the Prime Minister gets to appoint a new judge. But herein lies the controversy. In the American system, judges are picked by the president, but they also have to be approved by the Senate. President Trump's most recent Supreme Court pick is working her way through the Senate ratification process as I record this. This is said to be part of the American system of checks and balances, which holds that any powerful part of the US government should face oversight by another part. So the Senate can pass laws that the Supreme Court can then overrule, but the Senate also controls who gets to sit on the Supreme Court in the first place. So in theory, everything balances out. But in Canada, for some reason, this system was never adopted, not even during the reforms of the 70s and 80s. The Prime Minister remains the sole authority over judicial appointments, and whoever he wants on the court gets in automatically. This makes the whole appointment process quite pointless to care about, since no one but the Prime Minister has any control over it. The media barely even covers appointments when they happen. As a result, I would say that the vast majority of Canadians have no clue who is even sitting on their Supreme Court at any given time. Now, to be fair, for most of American history, this was the case in the US as well. The Senate would just unanimously rubber stamp whatever random judge the president put forth, and Joe and Jane, average American, didn't know or care who any of these people were. But as the US Supreme Court became more politically assertive in the post-war era and churned out more dramatic and controversial rulings, the US Senate also became a lot more aggressive in trying to control who did or didn't get on. This in turn represented the death of the old idea that judges were these fundamentally apolitical people who just made impartial decisions according to the law, who everyone should just trust. These days, if you say that sort of thing in America, you are likely to be mocked as either incredibly naive or dishonest. For example, Judge Amy Coney Barrett made this argument recently, and here is how popular left-wing YouTube darling Kyle Kulinski responded. Every judge says this, but it's BS. Right-wing and left-wing judges are all policymakers because the decisions they make are inherently political. There is no completely objective, literal interpretation of the letter of the law in every case. There is gray area and reasonable disagreement. So from this perspective, it is essential that the Senate be able to scrutinize, question, and expose the beliefs of prospective Supreme Court judges. Since anybody who gets on the Supreme Court will be making a lot of important decisions about these gray areas of the law, it is critical that the public know what their values and philosophies are. Again, I think this is a relatively uncontroversial idea in American life. In Canada, however, there is still a lot of faith among big shots in the media, politics, and legal profession that it is indeed possible for a judge to be apolitical and objective, even on deeply polarizing and controversial moral questions. And there's a lot of looking down on America for having such an unsophisticated political Supreme Court. For example, here is how former Canadian Supreme Court Justice Claire Laroux-Dubé, who was appointed by Prime Minister Brian Mulroney, put it in a recent interview with Maclean's magazine. What are the dangers of the politicization of the courts? It's a tragedy. We're not there to run the country, we're there to tell the law. Candidates' nominations are so bad, the politicians have a field day. In Canada, it is so different. I am so proud of our Supreme Court. Whatever their divisions, still, it's not politics, it's a difference of opinion, and on that, everyone can agree. The United States will destroy itself. Their battles of nomination are terrible. It destroys the credibility of the court. I think the key word there was credibility. This desire to keep judges appearing credible has become this huge obsession of the legal establishment in this country. The Canadian Supreme Court even tries to rule unanimously on everything these days because divided rulings imply that judges might disagree about the law, and that's also seen as damaging their credibility. Any efforts to reform Canada's judicial nomination process in a more American direction, meanwhile, tends to be opposed by all of the big legal lobby groups because it is also seen as hurting judicial credibility. Presumably, this also makes it easier for controversial lawyers to get jobs as judges. And now, to continue this conversation, let us hear from everyone's favorite Canadian lawyer, Montreal litigator turned YouTuber, Viva Frei, aka David Freiheit. David has a channel where he talks all about legal controversies in both the United States and Canada, so let's see what he's got to say. Hello, David, how are you doing?
I'm good, and yourself?
Oh, you know. Anyway, so my question, David, do you buy this idea that the Canadian Supreme Court is so much less political than the American one?
I buy it because I haven't seen it. I don't follow the Canadian Supreme Court at all as much as I follow the US Supreme Court, but it seems that everything is hyper-politicized in the US compared to Canada, although there seems to be a trickle-up effect that I'm noticing since I've started doing the vlogs. Perhaps I just never noticed it before and it's always been there, and I'm only noticing it now that I'm sort of fully immersed in it, but I do see that whatever we see happening in the States in some sense comes to us a little later, a little more diluted, but we take an influence from the social political scene that's going on in the United States. From what it seems on the Supreme Court, it just seems, I don't know if there's less like hyper-political questions of law that are working their way up, or if the court itself, just by enforcing the overall law of the land, doesn't really need to get political or doesn't get infused with politics. It just seems that it's not, and even when there are sort of split decisions or decisions where there's more than one judge dissenting, it tends to look like it's, on the law and not predictable based on a political model.
So you think that that is possible as a goal, that it is sort of possible to do that kind of sort of purely neutral, objective legal analysis, even when it comes to super contentious questions?
I think it's possible. I think it's difficult. I just think from what I've observed, we have much less of it in Canada, if only because I guess to some extent everything has not been politicized in Canada, whereas I can't think of anything that's gotten to the Supreme Court that is not essentially a political dispute at its core, above and beyond the legal questions.
So let me ask you your personal opinion. As we film this, the Amy Coney Barrett sort of nomination hearings are happening in the U.S. Senate right now. What do you personally think of that process? Do you think that that would be something you would object to if it came to Canada? If, say, our parliament had to vote on the nominees that a prime minister put forward to be on our Supreme Court?
I think it's a great idea. It's a great system. It's a great way to do a due diligence on a judge who's going to be, holding the highest judicial position in the country. Yeah, and I think also it's great from getting the public to participate in it. The nastiness of how it gets political and how it becomes politicized is the downside. The upside is that people know the judges, they get familiar with the judges and their histories, they get familiar with the questions that it might be coming to the Supreme Court in the future and how these judges might adjudicate on them, and it gets people participating in the process and taking an interest in it.
The Canadian Bar Association tends to really be against this kind of thing. And any time that, the government has even made the sort of the smallest tiptoes in that kind of direction, sort of opening up the nomination process for judges to the Supreme Court, they've really come down very hard against this idea of Americanization and politicization. Do so you don't necessarily think that those two things are sort of inseparable, that sort of as you sort of open up for accountability, you inevitably sort of politicize the system?
Well, so And now it's sort of, I go back to the Kierkegaard expression that life can only be understood backwards but has to be lived forwards. I've understood now in retrospect when everyone says that it is a political process nonetheless in Canada. Which prime minister appointed or recommended the Supreme Court justice, and we therefore sort of view the judgments rendered by those judges through those blinders or through that prism. So I don't think it's less political to have a one person appointing a judge or one politician appointing a judge than to have Parliament having their say in who gets through and who doesn't. It's no different to have it be subject to the majority of a certain group of politicians listening to it as opposed to one politician with a political orientation picking it. I just think I like the idea because it creates transparency much more than what we have now, because now they get appointed, there's no process. You take for granted that they're not going to appoint someone who's totally unfit for the job. And it's not like anyone is expecting or suspecting a prime minister of appointing someone who's incompetent. It's just a question of there's no transparency. They get up there, they do their thing, and they're there up until retirement. I like the idea of everybody seeing it, participating in it, and it becoming not, the flip side to the public participation is it becoming a public spectacle. And if you look back to the Kavanaugh hearings, you can sort of understand that that's the real downside risk. But I think the upside risk is getting people involved in the process and having them know who their justices are.
One thing I sort of talked about earlier was how the Canadian Supreme Court really tends to rule unanimously on everything these days. And in contrast to the American Supreme Court, where you have sort of like the liberal bloc and the conservative bloc, and you always have these, 5-4 decisions in which the two sides sort of stake out very sort of starkly different positions. Do you have much familiarity with sort of Canadian Supreme Court rulings? I know that you've read, plenty of US Supreme Court rulings, but do you think that kind of sort of pressure towards like compromise yields a different style of ruling?
It's funny, I'm not more familiar with the U.S. Supreme Court decisions. I've read countless Canadian ones. It's just that whenever they get up there, they're sort of grand principles of law. Usually, I remember mostly the criminal ones, the criminal Supreme Court decisions from law school. It's just weird. It seems that everything is more political in the States in terms of what gets up there, but it might also just be the decisions that get the attention, like anything dealing with immigration, anything dealing with elections. They're necessarily political, where we just don't hear about forget how many decisions get heard by the Supreme Court, but I was looking through it. I've seen some very boring decisions coming out of the Supreme Court. You don't hear about them because they're not litmus test decisions, they're not political decisions, and they don't make it to Fox News, CNN. So it might just be part of the whole ecosystem. Things get politicized because the media makes them political. The media then brings them to the public attention, so you hear more about only the political decisions, and then you tend to think that 90% of the decisions are political as opposed to potentially 10%, but that get 90% of the media attention. But one thing is for certain, it just seems that the Supreme Court decisions coming out of Canada, very rarely are they political or anywhere near as political as the United States. And I can think of a few, although I don't think it went to the Supreme Court, I think it was Court of Appeal. Right now getting to the questions of gender, and questions of treatment of adolescents with gender identity issues and language laws. I mean, that's where things get political as well, somewhat. But it's on a different scale than what we see in the States.
What is the root of what makes something a sort of political decision or a political judgment or a political question when it comes to the law? Because, I had this quote earlier in the video where a guy was sort of saying that, law, certainly like law at the sort of the Supreme Court level, it doesn't get there unless there's kind of an ambiguity, unless there's like sort of shades of gray and sort of unanswered questions and some degree of subjectivity sort of required. And so I guess sort of like the position that I think a lot of people make in the States, and I'm kind of partial to this idea as well, is that when things get to the Supreme Court level, the level of gray in the law, the level of subjectivity requires, cannot help but sort of force politics into the decision making. Do you agree?
Well, I would have agreed up until this year and following one case in particular, the Michael Flynn, what I've called now on my channel, the Michael Flynn Judicial Saga, which is, you think these are very gray zone questions, when does life begin type thing, what is self-defense, what does brandishing a firearm mean? You would think that there would be these gray zones, and there are. What I've become flabbergasted about is how, even on things that are, ostensibly more black and white than other things, like, for example, When do you issue a writ of mandamus? Under what context? These things, there are some issues that I've now covered in the vlogs that I've been doing, which I would not call gray zone. I would call black and white. And what is the total evidence of absolute politicization of the courts is the, call it judicial mental gymnastics that the judges will use that is virtually predictive, virtually not essentially predictive, but quite highly predictive based on political appointment. And you can know in the Michael Flynn case where the issue of a writ of mandamus came up. And the question was, does Michael Flynn get the writ of mandamus? And the court initially said yes, 2-1 Republican-appointed judges to a Democrat-appointed judge. Then it gets overturned by the full full panel of the Court of Appeal because it was 7 or 8 judges of 10 that were Democrat-appointed judges. Then you take a case which is invoking the exact same issue of mandamus involving Hillary Clinton and whether or not she should be forced to sit through an examination, a deposition, and you get the judges going the exact opposite way, just interpreting the facts and spinning it in the exact opposite way, depending on political orientation. It is an amazing thing. It's sort of disheartening. It makes you cynical because the vast majority of the time, depending on the question, if the question is remotely political, you can almost certainly look at the judge and know in advance which way they're going to rule. And it's even on black and white issues, they find a way to twist and turn to get it to what they want their political ends to be in the judicial system.
That's a very good point, because I think that you've sort of hit on a sort of important distinction of how sort of like there's many flavors of politics, right? So I feel like the way that I've sort of been coming at it and the way sort of I framed most of this video was sort of the idea that, like, politics is like the politics of right and left philosophy, right? So it's like you have a judge that has like a sort of philosophical disposition to the right, which makes him, say, side with big business, or you have a judge who's sort of philosophically disposed to the left, and maybe that makes him side with pro-choice things of that sort. But you're making a very good point, right? Is that there's kind of like what we could sort of say the partisan dimension as opposed to strictly the political dimension. If someone is sort of seen as a very high-profile sort of right-wing or left-wing celebrity or politician or sort of political figure, can they get a sort of fair shot under a judge that was appointed by the other party?
Not just in the judicial process, in the prosecutorial process, and we're seeing this left, right, and center, where you see certain entities being prosecuted or not being prosecuted, and you can again predict based on political orientation which way it's going to go, depending on the political orientation of the prosecution side of things. Who do they prosecute, and how hard do they prosecute them, and who do they let out of jail? Literally, it is enough to it's enough to turn any optimistic adult quite cynical about the system and the process.
And just sort of to bring it back to Canada, you would say that you've not seen comparable evidence of that sort of thing happening in this country?
Yes, that's an interesting thing. I've seen comparable evidence, not in the judicial process, maybe, but even then it seems, take a concrete example, Rebel Media, or CBC suing the Conservative Party for using some of their news material in a political campaign ad. Stick with Rebel Media first, because that one's more familiar, more fresher in my memory. Rebel Media was denied a press pass to cover the federal elections debate because the commission, which is a political body, did not grant them a press pass to cover the event. They then go to court to get an injunction to issue them the press pass. And first of all, I never would have thought to look at who appointed the judge, but it seems that the judgment that came out, whereas you could have otherwise predicted the outcome in the opposite sense if it were in the States, here it just seems that the law is applied somewhat more politically neutrally. The idea that this political organization in the first place might have denied a press pass to Rebel Media and True North was the other one. That's political, and you can anticipate that from political bodies that take their marching orders or owe their very existence to certain political parties that created them. But then you get to the court, and the court seems to apply the law more consistently with less partisan influence. And that's a particularly good example. CBC, I forget how that turned out. I'll have to refresh my memory if I can in a second. But in the Rebel Media, like political enemy of the Liberal government gets a favorable decision for them, at the very least on the interlocutory level. And if it were in the States, you could have predicted with virtual certainty how it would have ended up, depending on who the judges were, because you would have gone right to see who appointed the judge in order to know or to predict where it was going to go.
One thing I wanted to ask you specifically, since you are from Quebec, what do you make of this idea, that the Supreme Court of Canada has to have 3 judges from Quebec at all times because, the justification is that Quebec law is just so different from the rest of the country that, only sort of 3 Quebec appointed judges can sort of ensure that the Quebec perspective is properly understood. Is that legit, or do you think that's an example of politics?
At the risk of being very, I don't know if this is going to be politically incorrect. No, I don't. I think that is purely political. I don't. I am very proud to be a Quebecer. I am actually, supportive of some of the laws in Quebec which are there to protect identity of the Quebec people, the Quebec language. But that being said, now I can see resentment being born out of the idea that Quebec somehow has a unique identity that the maritime provinces are not entitled to protection of as well, or out west. The idea of having a minimum quota to represent Quebec but not every other province, I can see that leading to, what's the word I'm looking for? Resentment and problems. Do I think a judge from Ontario or another province would be incapable of applying civil law? I don't think so. I think they're all very smart by the time they get to that point, that they don't need to be from Quebec in order to assess Quebec law. I do think the point where you start saying one province gets certain guaranteed minimums, whereas no other province does, that is how you start sowing discord among provinces as opposed to unifying them.
The rationalization of it is that Quebec, and you sort of alluded to this, has this like civil law sort of tradition or system that is so different than what exists in the rest of the country. Is that, I've always been curious about this, and I think that like a lot of people sort of outside of Quebec have always been sort of curious about this, and we just kind of swallow this at face value because it's often sort of said, Quebec, they have this different sort of legal system than the rest of the country. Is that in fact a legit difference, or is it a very sort of minor one?
So bearing in mind, like I'm only certified civil Quebec law. I am not certified in the common law provinces, but we do. It's common law when it comes to criminal law. So I'm somewhat familiar with the common law system. It's jurisprudential based, but at the end of the day, all the civil law means is that we have a codified set of laws. Every set of laws at this point pretty much is codified. I mean, the Highway Safety Code is codified, tax law is codified. So our applicable civil law, instead of going to common law jurisprudence, we go to the civil code and we find the provisions of law. It's different, but it's exactly it's just a variation of every other form of law that exists in every other province. It's just that on the grand scale, common law provinces go by jurisprudence and the case law from previous years, whereas we have a legal system that's codified. But as far as it goes in practice, I don't think it's much different. We have a criminal code. We go to the criminal code for provisions of law, and we go to how the courts have interpreted them in the jurisprudence. It's not much different than in the civil code. We just happen to have a civil code that has 3,000 and change articles, and we go see how the courts have interpreted those articles. But do I think it's so radically different that we need 3 judges, 2 judges to have a certain amount from Quebec because Quebec civil law is so radically different from common law in the other provinces? From my understanding, I don't think it is. It's just that we have a book that has all of our provisions of law, and that's where we go to look for the answers.
And I guess sort of like your whole sort of YouTube career is a sort of testament to clearly like, as a Quebec lawyer, you are not so intimidated by the common law system of the United States that you're not able to sort of, offer your thoughts and deep analysis and commentary and that sort of thing, which, I suppose if we interpreted this in sort of like the most strict sense, you in theory shouldn't be able to do because you're such a product of a vastly different legal system and tradition.
I have never come across a question that there was not a provision of law for. So we have our civil code in the United States. They have their United States code, which is like a consolidated book of all the laws. You have your criminal section, you have your civil section. It's not much different. I mean, I haven't actually noticed much difference at all when it comes to understanding, what is trying to think of indictment or extradition. You go look it up, and then typically these things are in the somewhere in a code codified. I haven't noticed any difference in the questions that I've been looking up in the lawsuits that I've been covering in the United States system, despite the fact that it's common law, I've virtually come across a provision of a code that addresses almost every specific topic. Mandamus, subpoenas, trying to think of some other good ones that come offhand. Federal statutes and state statutes, like brandishing a firearm. There's provisions of law, and it's codified as well. So I really haven't noticed much of a difference. And as far as it goes, just being a lawyer and being trained in reading this legalese, which is drafted in such a way to ensure that lawyers maintain their monopoly over the practice, that's the only thing that I've found is particularly useful, is you can read this stuff, you can digest it, and you can know what questions need to be asked based on the way certain provisions of law are drafted.
Well, thank you, David. I knew I had to get to sort of the Quebec perspective on some of this stuff, just because my audience loves hearing about Quebec stuff. But thanks so much for your time, David. Big help.
My pleasure. It was good. I'll see you on the internet, I guess, at some point.
If you're interested in hearing more legal commentary from a Canadian perspective, be sure to check out his channel, and be sure to tell me what you guys think of all of this stuff. Which country has a better system when it comes to the Supreme Court? Canada or America? Let me know in the comments, and I will see you all next week.